And now we start with working group 1 of the work package 2. They will get equipped with some microphones and then come forward. I must also say that we are here present, like I think 65 people in the room, but we also have online participants whom I would also like to welcome. We don't see them, but they are currently listening.
I have a microphone now.
Ça y est, j'ai un micro, je peux commencer.
Okay, good. Dr. Scheif, dear members of the jury.
Dr. Scheif, mesdames et messieurs les membres du jury, je suis ravie de pouvoir vous voir aujourd'hui. Je suis responsable pour l'Association des experts de justice Allemagne et en tant que premier intervenant du groupe de travail aujourd'hui, je vais vous demander de...
The project first, and I am very happy to oblige. So I will very briefly outline those before I dive right into the specifics of Working Group 1, together with my Dutch co-presenter, Nico Kaiser, that is. But not only Nico and I have been dedicating much time and work on FindexII. We were able to draw on our group's perspicacious wisdom because our participants were quite active. So as the leader of Group 1, first of all, I want to thank our members who were always beyond reliable and helpful. And I imagine this very time-consuming project would have been much harder to do without the perseverance of our little work unit. In addition to the steering committee, project managers, our assistant Aurélie had always had an extremely patient and kind way to deal with our numerous requests. And I don't believe life was very boring for her in the last 2 years, so we do appreciate it. In general, the project is divided into 6 major work packages. Working package 1 is an organizational one, committing out of the steering committee, while working package 2 consists out of 3 working groups. In working group 1, we dealt with the criteria for judicial experts, and that especially in terms of competency, procedural knowledge, and ethical criteria. Working group 3, led by Rafa Oriana de Castro, dealt with the definitions of criteria to be met by bodies in charge of expert directories. They explore who should be in charge of assessing experts, where, how long, and why these experts should be on regional or national lists available to courts, and if and how they should be able to re-register once they disappeared from said lists. Working Group 3, led by Benoit de Klerk and Sasha Dahlen-Gilhus, dealt with the requirements for experts in order to be registered in a directory. What kind of education should an expert have at all? Do they have to have practical experience? Should they take an oath? Now the last 2 working packages are 3 and 4. Work package 3, led by Jan Wannemacher and Bertrand Lüth, worked in defining a process for the existence of a common nomenclature in the fields of expertise within the EU. Work package 4, led by Pavel Rybicki and Jerome Lemaire, is responsible for creating a demo IT tool for 6 pilot member states: Belgium, France, Luxembourg, Italy, Poland, and Romania. The aim is to interconnect the national lists and to set up a European search engine for experts. I will only mention these things very briefly because I am sure that the working packages will give you a detailed prescription of their very successful work later this afternoon. But the first part of this morning in Cologne belongs to Working Group 2, so no offense. Of course, we would always have common themes in the project, and it was difficult at times to keep them apart, so we tried to avoid redundancies in our presentations, but I'm afraid it will not always be possible. How did we, as Working Package 2, approach our task? In order to lay down minimal criteria, in phase 1 of the project, it had been necessary to gather information about requirements for experts. Some information has already been collected in national fact sheets, which were made available to us online. Those have been compiled by the European Expertise and Expert Institute within the framework of the first FindexII project in 2017, I think. Another survey with a questionnaire and general criteria for judicial experts was conducted by the member states. The questionnaires were made available to the jury. Therefore, due to time constraints, I will not explain them in detail here again. However, the questions that emerged from the questionnaires will also be addressed in the general presentations, so you will get a good picture of what was asked in them. In each working group, the information on the countries was collected and double-checked. If further information was needed, the work group mainly consulted the European Expertise and Expert Institute and EuroExpert, and we sometimes even reached out to ministries and experts in the individual countries. When all that information was gathered in phase 2, we evaluated the questionnaires and identified the questions that were important for respective working groups. And that is, dear jury, how our deliverables were created, where the group leader would usually draft a first design and then circled and circled and circled within the group until a version was ready that everybody agreed on. So let's just dive right into the working group 1's outcome. For all judicial experts, it must be ensured that they meet sufficient quality standards. This must happen to ensure mutual trust in expert services and experts' opinions. In the very first place, of course, national law lays down the responsibility of experts. Therefore, member states stipulate the requirements like education, training, and certification. But we often have the situation that experts provide their services across borders throughout Europe. So there need to be some kind of a common criteria for all of us. And the very first minimal criterion we all agreed on was that judicial experts are appointed to provide an independent and impartial opinion on a matter that is in dispute. Typically, that happens in cases where judges or parties require specialized knowledge to help resolve an issue, that is. Our first relevant finding was that it is generally recognized within the member states that the quality of an expertise service depends on professional competency, impartiality, objectivity, independency, and integrity. But these criteria are implemented rather differently in individual countries. And that is, dear members of the jury, why we have FindexII. I think I already talked about our sources. And from all this information, we as Working Group 1 studied how the qualification expected from experts look like in different EU countries. Then we tried to identify common criteria and major differences. In addition to this, we as a group of different nationalities, backgrounds, genders, also provided carefully considered advice on qualifications that we believe to be an important asset for experts who work cross borders. So what were those sad observations in different member states? First of all, 23 member states have official registration systems for judicial experts. One of the main differences is seen in the bodies, which are responsible for the registrations. These are either courts, ministries of justice, or other mandated bodies, as well as private institutions. And another difference can be seen in the coverage of disciplines and the usage of experts, for example, only in criminal cases. Some member states cover all disciplines, some only a part. Experts' activities are carried out additionally to the main profession, like being an architect, being a craftsman, being a doctor. So experts must therefore provide that they gathered knowledge as well as experience in a certain profession. Only after that, they can work as an expert. They carry out their activity as expert for the judicial systems, and this position comes with a number of requirements. These were the most important criteria that we observed in the member states. Competency. I will talk about competence now, and Nico will talk about the other requirements later on. Experts need professional knowledge through initial education and experience. Generally speaking, competency helps achieve the intended results and should always include an up-to-date work standard. The survey showed that 12 out of 21 member states require a judicial expert to have an academic background, which is Belgium, Bulgaria, Croatia, Cyprus, France, Italy, Malta, Portugal, Romania, Slovak Republic, and Slovenia. Indeed, there are some fields of expertise where a university degree is highly recommended. Same goes for a membership in a professional organization. We observe this in medicine or architecture, just as an example. However, it should be noted that educational systems in different member states vary greatly. In order to learn a profession, in some countries it may be necessary to complete a course of study, while in other countries an apprenticeship is sufficient. The relevant criterion, long story short, is whether an expert has knowledge above average in their specific field of expertise. So what is our special proposition here? In summary, we propose experts shall possess professional qualifications and/or professional education to guarantee theoretical knowledge in their field of expertise. This can be verified either by an academic training or education. In some cases, many years of specific professional experience may also suffice. Let's now talk about experience. In Croatia and Germany, for some areas of expertise, it is mandatory to give evidence of experience in order to be accepted. This experience may be proven by expert work outside of courts, like for an insurance company, for example. The other member states do not require this at all. So if we talk about professional experience, we must note that 10 out of 21 member states answered that they consider professional experience to be a basic requirement for experts. Austria, Bulgaria, Croatia, Czech Republic, Denmark, France, Germany, Ireland, Romania, and the Slovak Republic. And most of these countries require 3 to 5 years of practical professional experience. Conversely, 7 countries answered they do not impose this on experts, which are Belgium, Cyprus, Italy, Malta, Portugal, Poland, and Spain. Finally, 3 countries gave no opinion on the issue at all: Finland, Lithuania, and Luxembourg. So our recommendation is experts shall have professional practical experience of several years. The position of a judicial expert is considered less suitable for a beginner. We suggest that the position even requires practical experience of a minimum of 3 to 5 years. But to give specific evidence of practical experience as judicial experts should not be mandatory, because this way we would be in some kind of a catch-22 situation where there would be literally no chance for aspiring experts, and we really need them because of the age gap in most countries. So any kind of professional experience should suffice here. An expert does not necessarily have to be in the acme of his professional success while starting his work. Competency usually goes together with an ability to present clearly, so that an expert's opinion will be understood by a non-expert, both orally and in writing. So we need to add, this was not directly targeted in the questionnaire of the survey, but it is still something we all agreed on. In 6 member states, it is mandatory to be a member of a professional organization in order to have professional experience. The Netherlands stated that although there is no real legal requirement to do that, the expert is required to be a member. Experts also shall follow continuous professional development, CPD in short. While knowledge of civil procedures generally has a fairly long half-life, technology and scientific methods develop faster and faster. Experts constantly shall be prepared to adapt their working methods when professional experiments nowadays are rapidly changing. Lifelong learning is the key to pick up new knowledge on a regular basis. This also equals mental flexibility to acknowledge changes in the field of expertise. For experts, it is therefore important to make sure they have regular learning time built into their schedule. Maintaining an up-to-date knowledge can be achieved by undertaking appropriate training, and 13 member states require this explicitly for registered experts. The common requirement for an up-to-date knowledge in a specific field of expertise sometimes comes with an age limit. This is the case in France, for example, while in other member states of the EU, this is considered discriminatory. And so the very last criterion I talk about before I ask Nico to take over, the second part of the recommendation is the knowledge on procedural rules. Following the survey, 9 out of 21 member states consider procedural knowledge as necessary, which is Austria, Croatia, Czech Republic, France, Germany, Italy, Netherlands, Romania, and the Slovak Republic. Some countries require no procedural knowledge at all. Well, in some countries, such as the Netherlands and Germany, there are institutes that provide special training for judicial experts. Other countries, like Austria, offer a one-day training to expert candidates. In France, Association of Experts organize such trainings, and some universities of law offer a degree of such manner. In Belgium, there is also a precise regulation of the legal training measures. Our working group's opinion is knowledge of the law and the applicable legal system is significant and should belong to the knowledge of a judicial expert. They should be aware of procedural rules in the applicable jurisdiction. This is why our advice is experts should have knowledge of procedural aspects, at least regarding their rights and obligations and their function within the legal systems, since an independent and working functioning legal system is a backbone of a constitutional state. And experts should globally know how the results of their work will be used in order to deliver results that are of use for courts. So experts shall possess at least basic knowledge about civil, criminal, and administrative procedures, and this should include relevant codes or rules of practice for experts, an overview of the relevant justice system, criminal and civil procedures, and knowledge of their roles and responsibility as experts. There should also be some kind of understanding of alternative dispute resolutions, ADR, including mediation and expert determination. So this was a more competency-based side of requirements for experts, and now there are also, of course, ethical requirements for people working for the judiciary, and you could also refer them under the Euro expert catchphrase of being a fit and proper person. And that is a part of the deliverable that Nico Kaiser, one of the 2 vice presidents of the European Expertise and Expert Institute, and a prolific expert for technology and data protection, is now presenting.
Thank you very much, Verena, for the introduction and also for the first part of the presentation. Members of the jury, thank you for being here. My name is Nico Kaiser. I am IT expert in the Netherlands, but I'm also vice president of the EEI, as Verena already mentioned. But I am also Secretary General of the Dutch National Registry of Judicial Experts. Oh, there's 2 arrows on it. I'm an IT expert, right? And I could not use this. There are 2 arrows to my Okay, as Verena went into the professional knowledge of the person and procedural knowledge, our investigation found that there's also a lot of ethical aspects that judicial experts should meet. Sometimes, to my personal surprise, some ethical experts were not really mentioned in the questionnaires. But I remind you that we are not looking, at this moment, we are not looking into what is to be advised, but we are looking into what we have found that is the common standard for all countries. The ethical experts we want to talk about is impartiality, independence, objectivity, integrity, conflict of interest, duty to the court, confidentiality of the cases, and transparency of expert opinion. And I must say, they are all intertwined. Within the working group, and even this morning, we spoke about the difference between independence and impartiality. And it's not very clear. Verena mentioned already that all member states interpret these aspects differently. But it's intertwined. If you're not independent, you cannot be impartial. If you're not independent, you have a conflict of interest. You cannot have a good judicial or expert opinion. So it's all intertwined with each other, but it's very distinct to make sure all the aspects are covered. As you see, the majority of member states find impartiality and independence noted in their systems. So impartiality refers to the expert and its interior motives, and the expert opinions rendered by the expert as a result of professional investigation instead of listening to what one of the parties is telling you what the result of the expert opinion should be. And independence is assessed in the relationship between the expert, the parties, and any person in the judicial process. We may find independence in many forms and shapes, both internal and external. Within our Dutch registry, we ask judicial experts that are employed to always sign a declaration of independency. But independence is also related to conflict of interest, which we will see in a minute. In basic, the judicial expert shall not do anything in the course of practicing as an expert in any manner which compromises or impairs or is likely to compromise or impair the expert's impartiality. Then we come to objectivity and integrity. The aspect of objectivity and integrity appeared from several answers and notions in the country member states' questionnaires. Several codes of conduct of practice in member states refer to objectivity. In this matter, also, duty to the court is mentioned as a relevant way of behavior for the expert. The duty lies with the appointing court. That is who the expert is informing with his expert opinion. I will come back to this aspect later again. Objectivity is about scientific or technical knowledge with the expert. An expert should be able to separate its private opinions from professional point of view. It should be purely fact-based. An expert shall not be influenced by unreasonable fears or dislikes of something or somebody, and he must be prepared to revise prior understandings that are refuted by new scientific findings. Verena mentioned continuous professional development. I work as an IT expert, already artificial intelligence was mentioned. That is going to be a huge shift in the way IT experts will investigate applications and software. Professional integrity values honesty, honor, and truthworthiness. And in concrete terms, the respect expected from the expert implies a firm condemnation of all racist, sexist, and homophobic remarks, because they influence the process, and you cannot have that when you're looking at a fact-based process. I come back to conflict of interest. The expert must notify, prior to any appointment, if there is a conflict of interest or a possible conflict of interest. I always use the test with myself. If somebody writes this in a newspaper, will I be condemned for it for taking this mission? If that is the question, yes, you should not have that mission. You should not do that expert investigation. But this conflict is about all previous mentioned ethical experts. It's about independence, it's about impartiality or possible conflict of interest. If you are in financial difficulties, you might find grounds to accept a mission which you objectively seen should not be accepted. You are not impartial if you have previous knowledge or had previous contacts with either one of the parties. If you have published strong opinions on a scientific matter, you may not be able to investigate that particular case objectively. And if you fail to be transparent about all of this, you might not be integer or even be corruptible. So the expert should at all times prevent the expert opinion being compromised. Sorry about that noise. In the majority of member states, 14 out of 21, a duty to the court is considered a fundamental requirement. Most member states relate to the Human Rights Convention right to a fair trial. And the court should be provided with truthful, independent, impartial evidence by the expert. This duty, however, should not be misunderstood as an anticipatory obedience for state authorities or as a recipient of politically driven orders. Like in common law systems, the duty to the court is stricter than in civil law. In common law systems, it is commonly accepted that party-appointed experts function as independent and impartial experts for the court. They are even paid by one of the parties. And under civil law jurisdictions, however, the duty to the court is mostly reached by the fact that experts are appointed by the courts themselves. Confidentiality. A bit to my personal surprise, only 13 out of 21 countries have confidentiality responded as a needed aspect. However, we recommend to have this aspect added to codes of conduct or codes of practice, or at least in instructions when appointing judicial experts. However, I do point out the fact that it's not mentioned in the questionnaire does not mean that the expert in the other 8 countries do not work on a confidential basis. It's only not explicitly mentioned in the questionnaire or in the codes of conduct. Then we come to the last ethical aspect, transparency of expert opinion. In this matter, many times the proper standard of work is mentioned. The expert opinion the expert must be able to apply knowledge and skills to achieve the intended result. His or her approach must be explained in the expert opinion and must be clear. Reasoning must be clear and transparent, and above all, the expert opinion must be motivated properly. Experts must also be able to deliver their expert opinion in time, as the ongoing of the legal proceedings is relying to that. Only 10 member states expressed that demand explicitly. As a spontaneous reaction to the questionnaire, some member states added that judicial experts should not have a criminal record. If we see each other here, we find that very reasonable. Only little member states mentioned it. In most member states, this is solved by a statement of conduct or like, issued by a governmental or any official representative. At last, we were informed about the age limits for judicial experts. In few countries, a limitation of age was set by a maximum and a minimum age. Please note that the working group acknowledges that compliance with some of the requirements previously set and that you will be hearing later today require a certain amount of experience in the work. If you're 22 and fresh out of university, you will probably have a lot of knowledge, but will not have the skills and ability to be an expert. But a formal age limit to enter as an expert, or a formal age limit to be resigning as an expert, is something we do not recommend. And we say we do not recommend an age limit for experts. We can also say we recommend not to have an age limit for experts, which is a slight difference. Our presentation was about the document that Working Group 1 delivered. That document may be used as a basis for discussion. That discussion may start even in a few minutes. This debate will improve transparency and understanding. As I have explained, as we have found during our working group work and within the whole project, is that there are many differences. There are differences in the way we look at things, the way we work at things, the way we name things, the way we use the wording in our process. But this debate may improve transparency. And sometimes it's not very easy to imagine that something you do in your perception is the right way is criticized by others. And we see the need in harmonizing procedures and above all to have minimum EU standards. And a side effect of harmonizing these procedures is setting procedures and writing them down. And this might make entry of young talents easier to become a judicial expert. And that's the end of my presentation. Thank you.